Hi, it's Rachel from FitLegally. I am not only an athlete, but I'm also a lawyer that works with fitness biz owners, which is where the name FitLegally has come from. I own a law firm separately from FitLegally, and we do a lot of small business contracts and intellectual property, trademark, copyright stuff. And I want to utilize FitLegally as a platform to talk directly to you fitness business owners. Whether you're a coach, a nutritionist, maybe you're just a fitness brand that's selling products to athletes, it's important that you guys understand a lot of the legalities that are going on. For this video, I want to talk specifically to coaches that are working online. The reason for this is, shameless plug, I just released an online coaching contract template form in the FitLegally shop. You can immediately download. I worked with multiple coaches on this, and you guys can utilize it with your customers, with your athletes that you're going to be working with. Now, this video is not just to be a sales push for that. It really is to try to convince you or provide a little bit of more of a legal framework for utilizing contracts in your business. I think one of the things that fitness biz owners, especially coaches, are very apprehensive about using contracts in their business because of this negative connotation we hear about gyms and the way that they put people on contract and you can't ever break them. But I want to share with you that fitness contracts are not going to be like that. Having an online coaching contract, much like what we have, or you guys can look at the product description and have your local attorney drafted as well, having this in place is going to do a couple of things for you. One is going to provide legal protection. It's going to create the legal relationship between you, the coach, and the athlete. The reason for this is, even if you don't have a contract, you're going to end up creating a relationship anyways, but it's not going to be governed. It's not going to have all the specifics in there like you would have in a contract. So the contract creates it, but then the contract also governs that relationship. Let's say that I just call you up as an athlete. I want you to coach me online, and we just fly by night, don't provide any contract for me to sign. I'm not going to know the expectations. I'm not going to know what I'm supposed to receive, which is going to be point two I'm going to get to here in a minute, that it can lend to a lot of miscommunications, misexpectations, and unfortunately issues can arise. But I think the biggest thing is that when you don't have a contract, you're still in a contractor relationship whether you realize it or not. You offer your coaching services, an athlete accepts it, then typically the athlete will pay you in exchange for those. You guys have created a contract together, whether you realize it or not. The problem with that is that you don't have any legal protection around it. So let's say a problem arises, right? And your athlete is upset, or your athlete's missed payments and you want to try to enforce. It's really hard to enforce those sorts of terms if you guys have not put it all into one central writing. Again, you're in a contract without having a writing, but it's not really governed, and there's no real way for you guys to point to come back together as coach and athlete to continue to try moving forward. Because a lot of the legal issues that I see happen are from miscommunication, misunderstandings, missed expectations, which is point two. Your contract is going to set the expectations for both parties. Not only is it going to provide the legal protections, which I'm going to dig into here in a little bit, but it's also going to outline exactly how to get into the relationship together, what happens during the course of the relationship, and what to do if there's a problem. Maybe an athlete has paid all this money and a coach doesn't deliver. What is the athlete's options of recourse to resolve that dispute? Well, having a contract in place, we're going to be able to clear out exactly what everyone's going to receive, the obligations that everyone is supposed to do under the agreement, and there's not going to be miscommunication. Like I said, the majority of legal issues that we see are either from no contract or a really crappy contract. And what is that resulting in? Miscommunication, misunderstandings between parties. And contracts can help clear that up immensely. And third, what I absolutely love, one of my favorite things to say about contracts, is that yet the contracts not only speak professionalism for you as the coach or the business owner, but it allows the contract to be the no man wall. You're going to be able to stand to your policies without either getting run over or seen like you're the bad guy in the situation. Let me give you an example. Let's say that a client has missed payment a couple of times and you, the coach, are getting frustrated and you just want them to start paying on time. Maybe you want to be compensated for that administrative oversight, such as through using late fees, which, by the way, you can't arbitrarily add those unless you have it written in the contract. But say a couple of times an athlete has missed paying, and you, as the business owner, as the coach, can say, that's okay, I know you have a lot going on, you can waive it. But what if you get to a point that you feel like you're being absolutely abused, right? You can then point to the contract and say, per the contract, if you miss another payment, we're going to terminate our relationship. Or per the contract, you owe me X amount of dollars for the late payments. And it allows you to help preserve the relationship and lets the contract be the no man, be the bad guy in the relationship. Does that make sense? My goal with having contracts is to educate, create the legal relationship, set the expectations, but also allow you guys, the parties that are involved, to be able to still salvage any sort of relationship that you may have, because we don't want to jump to legal action. That's not why I'm recommending contracts. In fact, that's why I'm recommending to use contracts, is to avoid any sort of legal issues you're going to have later on down the line. Now, I know some of you are probably sitting there thinking, oh, well, I don't need to worry about this. I've never had a problem. Never have an issue till you have an issue. Or even if my athlete quits paying, I'm not going to enforce this against them. But guess what? Your athlete can still try to enforce against you, and you want to try to govern that relationship. So what does this look like? Obviously, I probably convinced you by now to have a contract in place, but we want to make sure that we have the right things in the contract. At a baseline, and you guys can dig into the FitLegally shop and see what contracts are in there and their descriptions. I do it bullet pointed, so you're welcome to take that as a checklist to your local attorney. But for things like online coaching or just coaching in general, you want to make sure you have some very basics. Who are the parties? You and the athlete. What day are you signing this? Who's receiving what? What is the athlete going to receive from you, and what are you going to receive from the athlete? That exchange is typically money for coaching services. My online coaching contract, we go into specifics of also, do you get a consultation call? What is the access by email or text? How are the plans delivered? Are the plans one-to-one customized, or are they just a standard plan that you use for all 70.3 or 140.6 athletes? These are very specific services that you want to outline. This section right here that I just said to you really quickly like that is what is completely and utterly missing when you don't have a contract at all. And that is where a lot of the miscommunications and the missed expectations occur between athlete and coach. Because an athlete may get into the relationship with you as the coach, love you, excited, has seen your Instagram, has seen your time, seen what you've done with other athletes, and they may be expecting this one-to-one, fully customized, 24/7 access with their coach. But then when they get into the relationship with you, because there is no contract to set these expectations, they realize that you're not going to provide all of that. Or then you as the coach feels like you're stuck offering all of that, which in turn maybe realize that you needed to charge more because now you're spending endless time texting and calling with your athlete versus setting a little bit of restrictions and limitations on that. And how can that be done? In the contract. Now, other things we want to include in there are going to be like waivers and questionnaires and all of that you want to fill out. You can look at the whole product description that I'm going to link for you guys. But I really want to dig into the legal miscellany section, because this is the portion of contracts that's often missing when you draft it for yourself. Do not draft it for yourself, okay? Do not draft it for yourself. Or if you don't have a contract at all, you don't have this section, obviously, because you have no contract. This legal miscellany that I'm referring to is a lot of boilerplate. Things like, what happens if there's late payments or missed payments? I already mentioned, you can't just arbitrarily assess late fees without having it agreed to in writing. And many states are regulating the amount of these late fees, so you need to be able to be sure that you're in line with the state required amount or the state threshold that you have. Another thing is, what happens if you need to enforce the contract against your client, or your client needs to enforce it against you? Where are you going to do that? Or maybe you're coaching someone in California and live in Florida. Guess what? Without this section in your contract, without having a contract at all, if your client in California has a problem, they can walk into court in California and try to pursue a claim against you there. What does that mean for you? That means you're going to have to hire California counsel. You might have to travel to California, and it's going to be very time intensive and financially cumbersome for you to do that. How can we manage this? By putting into our contract. The coach is going to have the contract present this to the athlete. So you'll have a section there under this legal miscellany that's going to talk about how you're going to resolve disputes. Maybe you want mediation, arbitration, or at least confine it to a specific jurisdiction, as well as what law is going to apply. Because again, if you're a Florida coach, you don't want California law to apply to your relationship. probably want Florida, and you also want the convenience of being able to go to court in Florida. Can only do that, and you can also reduce a lot of battling in court about that by simply agreeing to it in contract. But perhaps one of the most important things that you guys need to have in here, and again, remember I mentioned earlier the idea you might be sitting there thinking, oh, I'm never going to enforce it against my client. But guess what? What if the client tries to enforce something against you and you don't have a writing? Attorney's fees. I'm going to tell you guys, this is probably one of the most important sections here in this legal miscellany. The dispute stuff is pretty important too, but the attorney's fees provision is absolutely one of the most important things. And without a contract, you don't have it. And with a crappy contract, you may not have it. What does this look like and why is this so important? The only way you can receive attorney's fees under U.S. law is to either have it prescribed by law, which a standard breach of contract is probably not going to have that. It's not going to fall under, or agree to it in a written contract. It's the only way you can do it. So take it out of your mind, A, I'm never going to enforce against the client. You never know what's going to happen. You also never know if that client's going to come and want to enforce against you. And then you don't want to have to expend the money in order to have to defend yourself. And what if you're right? Well, there's this idea that if I win, then the other side pays my attorney's fees. That's not how it works. That is not how it works. That's not how any of this works, right? So what does this mean? We want to have a written contract. We want to make sure we have all the things that I have outlined, as well as looking at the product descriptions I have on FitLegally. But we definitely want to pay attention to any sort of contract that we have in services agreement, that we have this legal miscellany, very specifically the attorney's fees provision, because you can't just simply, if a client has an issue with you, an athlete has a problem with you, and they file a suit against you, because it happens, you can't just simply say, well, I didn't do anything wrong, because you still have to show up to say that. You can't just say it and it goes away. You still have to show up to say it, and you may have to expend some attorney's fees money for that. And the only way that you can get the losing side to have to pay for your attorney's fees would be through a prevailing party attorney's fees provision. Now, this video is, really the intention was to be quick and to the point. I'm going to do follow-up videos for this. I'm more than happy to talk one-to-one with you guys as well, so feel free to PM me about it, or email rachel@fitlegally.com. This is just high level. These are just some of the important things that you need to ensure that you have. Have a contract. Make sure it's lawyer drafted. That's what I did. And I worked with a couple coaches on it to make sure that it's in line. You also want to make sure you have the most important specifics. Payment. What happens if they miss a payment? What services they're going to receive? What other requirements do you have? Do you require your athlete to give health history, exercise history, et cetera, et cetera. You also want to have waivers for assumption of risk, so that your athlete understands that they're assuming the risk of a certain activity, all the way through all this legal miscellany that I just very briefly outlined for you guys. So please understand that you need to have a contract. It's going to set expectations. It's going to create and govern the legal relationship with your client, because guess what? It's happening whether you realize it or not without one, and to make sure that it is going to be there for you in the end if you have any problems, because you never have an issue until you have an issue.